public company having share capital is required to file with the ROC. ROC, Registrar of Companies, either a prospectus or statement in lieu of prospectus. That is a requirement. These documents to be submitted to ROC. The prospectus and the statement in lieu of prospectus. The company, public company who is having a share capital, and that the company has compiled with the requirements of Section 149, Section 149 of the Company Law 2013, on being satisfied that all the formalities have been compiled with, and the registrar shall certify that the company is entitled to commence business. So after completion of all the legal formalities, after complying with all the provisions in respect to the commencement of business, the public limited company can start its business after getting the certificate of commencement of business. This is a requirement you have to compile with. You have to submit a copy of prospectus, you have to submit a copy of statement in lieu of prospectus as per the requirements of the Companies Act. You have to deal with all the formalities in respect of the in respect of the commencement of business, and you have to submit all these copies signed by all the members of the company, stamp of the company, commencement of the company, and retain one copy and submit one copy to the ROC for the purposes of the commencement of business. So that is a privilege. Available to a private company. A private company can immediately start its business, commence its business after obtaining the certificate of incorporation. But that is not in the case of public company. Public company has to wait, has to obtain so many legal formalities in respect of commencing the business as per the Companies Act, as applicable on that particular company, has to go through that all the formalities. Then after verification of all your documents, there is no objection on the part of the registrar. The registrar will issue you a certificate of commencement of business. If there is no objection, if there is any objection raised by the registrar, then you have to deal with the objections. You have to make it correction as per the requirements of the company law, as per the requirements of the registrar of the company. So you have to fill all the columns, whatever required for the purposes of commencement of business. Then come to the doctrine of indoor management. This is a doctrine, and doctrine means you can say rule of law as applicable to company. And this is a doctrine. Indoor management is an exception to the doctrine of constructive notice. It is important to know that doctrine of constructive notice does not allow outsiders to have notice of the internal affairs of the company. So outsiders, they are unaware of the internal affairs of the company, so they take advantage of this clause, the doctrine of indoor management, because everything is as per doctrine of constructive notice. Whatever information company have, company provides to their shareholders, members of the company, or prospective investors of the company, or prospective general public, available at the register office of the company, all the important documents of the company. So everything is a notice. It is a duty, it is a responsibility of the investors to be informed and get notice, read all the documents carefully before taking their decisions to invest into the company, into the shares of the company. This is a doctrine of constructive notice. So all the important documents of the company, whether it is MOA of the company, A of the company, and reports of the company, and returns of the company, all documents to be kept at the registered office of the company. And any person who are interested to see the documents of the company can see the documents by payment of nominal fees as charged by the registrar of companies. So by payment of nominal fees, the any person can avail the information about the company. That is after a constructive notice. Everything is available at the register office of the company. It is the you can say responsibility of the investors to read all the documents, whatever information is available at their end before taking their decisions to invest their hard-earned money into the company. So this is a doctrine of indoor management, very very important case in this, the Turkant case, the Turkant rule, and this is based on a landmark case with the Royal British Bank versus Turkant, and the year of the case is 1856. Then come to the facts of this Turkant case of doctrine of indoor management. So as per this case, the directors of a company were authorized by the articles to borrow on bonds such sum of money as authorized from time to time by resolution of the company in general meeting. So we assume that this type of resolution has been passed by the company. The directors are authorized by articles to borrow bonds on such sum of money as authorized from time to time by resolution passed on the company general meetings. So as an investor, as a shareholder of the company, assume that such a resolution has been passed. So doctrine of indoor management. So director gave a bond to T without any authority of any such resolution. There is no such resolution passed by directors in the board meetings in regard to the giving of loan or bond to T. The question arises whether the company was liable on the bond. So company was liable on the bond because we assumed as an investor, as a person, we assume that company run all its activity, company maintain all its accounts, and company file all the take all the resolutions, conduct all the meetings, and passing all the resolution, whether ordinary by nature or special by nature. As investor, because we assume that the company passed the resolution, on that basis the company is liable on the bond. Okay. So company was liable on the bond to pay, and T was entitled to assume that resolution of the company general meeting had been passed as per doctrine of indoor management. So, so the T take advantage of this doctrine, this rule of law of indoor management, and this is a famous case, Royal British Bank versus Turkant case. Very very important, and because as a investors of the company, as a shareholder of the company, we assume that company run its business in a proper manner as per the compliance of the Companies Act, as per the provisions of the Companies Act, and directors of the company were authorized by the articles to borrow on bonds and such sum of money as authorized from time to time by resolution of the company general meeting, and the directors gave a bond to T without authority of any such resolution because and the question is whether the company was liable on the company was liable. Also, liability of member is limited, but here in this case, the liability a company is liable on the bond. Then come to the exception to the doctrine of indoor management. Exceptions are there in this rule of law. Exceptions are there subject to this whether we are able to avail the advantage of doctrine of indoor management, but there are certain exceptions based on these cases. Number one is when you already know about there is something irregular, something inappropriate, and some misconduct on the part of the company, and we have a knowledge of that. In spite of that, you are taking advantage of this doctrine of indoor management, and that we are assuming that this happened in the company. But if you know that this is not happening in the company, you have a knowledge in your knowledge that this type of irregularity, this type of misconduct in their regular functioning is happening in the company, and you are aware of that. And in spite of that, you are going to take advantage of this principle to can't take advantage. So if you want to take protection under this law, doctrine of indoor management, you can't take because you already know that this happened inside the company. If you say that I don't know this happens inside the company as per the structure in load management, a company is free to run their business as per the laws of the company, as per the articles of association of the company. And we, as you, if you say that we are unaware that this type of things, this type of misconduct and malfunction is happening in the company, ill practices in the company, and you are aware that this happens, you are aware that there is something insider trading in the company, aware of that, and still you are taking advantage of this rule of law, you can't able to take advantage. As per the case Howard versus Patent Ivory Company. Then come to the no knowledge of articles. The rule cannot be revoked. You should have a person who do not consult the memorandum and articles. You should have knowledge of the MOA of the company and A of the company. You can't say that we have no information about the MOA and A of the company. As a responsible citizen, you should have knowledge of articles of the company, memorandum of the companies. You can't take advantage of this doctrine that sir, I have no knowledge of this article, I have no information. So, because company provides all the information as per doctrine and constructive notice. If you are not aware, it is your responsibility. It is your duty to have information about the internal affairs of the company, about the memorandum of the company. If you don't consult these two important documents, it is your mistake. The rule cannot be invoked in a person who did not consult. You have to at least consult the memorandum and articles. Then forgery is there. The rule of indoor management does not extend to transaction involving forgery or otherwise void illegal application. It does not provide protection to transaction, that is, a fraud element is involved. Fudging of account is involved. If you are cheating is involved, cheating element is involved, and that is declared void in the court of law, void illegal. Illegal transaction is declared void in the court of law. If you are doing a transaction, the purpose is to fraud any person, to cheat any person, you can't get protection under doctrine indoor management. If your intention is to defraud others, to cheat others, to involve in fudging of accounts, manipulation of accounts, that is your objective. In that case, you can't able to take protection under the doctrine of indoor management. If your intention is to cheat another third party and cheat your investors, in that case you have to this rule is not applicable, doctrine of indoor management. There does not provide protection to this rule. Then negligence. Negligence means carelessness. In no way you have to behave negligently. You have to see all the documents. You have to inspect all the books of accounts, inspection of books of accounts, investigating all the books of accounts of the companies, important documents of the company, before taking decisions to invest into the company. So negligence, carelessness on your part is not acceptable as per this doctrine of indoor management, and it is no way reward to you. If you are behaving like a carelessness person, if you are behaving like negligent person, this rule does not give you any benefit or advantage. So these are the certain exceptions to the doctrine of indoor management. Meaning is that if you have knowledge of irregularity, if you already know that something wrong happened inside the company, some persons are involved in insider trading, gambling, and money laundering. So if you know these elements are there, already you are aware that how can you take advantage of this clause of in indoor management? If you are not knowing, if you are not consulting, if you are not taking advice for your decisions to invest into the company by having a memorandum or articles of association, then you can't take advantage, you can't avail the benefit of doubt. Because meaning is that you should have knowledge as a responsible person of India. You should have a knowledge of articles or session of the company in which you are investing your money, investing your funds into the company. So for that you should consult, you should take advice. Uh, you should read these important documents carefully. The MOA of the company, the A of the company, without having consulting, without having taking advice in respect of your investment decisions, and you are investing, and now you are taking advantage of this doctrine, then exceptions are there. Then fraudulent element is there. The rule of indoor management does not extend to transactions involving fraudulent or otherwise void or illegal or ab initio. Illegal means if the transaction motive, the motive of transaction is to uh, fraud others, to manipulate the accounts of the company, to intention is to cheat. That is cheating. Fraud element is there. Fudging is there. Fake element are there. So that is not acceptable. That is not acceptable in the court of law, and that transaction is declared void in the court of law. So you can't take the rule of indoor management does not extend, because your objective, internal objective is very wrong. Objective is illegal. Objective is unlawful. If it is your objective is unlawful, how can you take advantage of this principle? So, as a capital providers to the company, as investors of the company, as a shareholder of the company, it is your duty, responsible to behave like a weird person, to behave like a mature person before your decisions to take invest. Otherwise, no rule can save you. No rule. You have to save yourself. No one can save you. You have to save yourself. So then come to the very very important topic of the Companies Act of the company. It's about lifting of the corporate veil. Lifting means you have to lift your veil. Veil is the curtain. You have to lift the curtain, corporate curtain, to see the persons behind the curtain, to see the person behind the entity, the person behind its legal existence, who are the persons who actually runs the affairs of the company, who are the persons who actually controls the affairs of the company. For that purpose, we have to lift the curtain to see the real persons, the actual persons, those who actually runs the company, not the person who are in picture, but not the persons who are not on the picture, but they are actually they are running the very very important financial matters of the company. They are taking very important decisions of the company. So we have to find out the persons who are behind the affairs of the company, who are responsible for the downfall of the company, who are responsible for the dissolution of the company. So for that purposes, we have to lift the veil. Veil means a curtain, a corporate means a company, and lifting means you have to just lift the curtain. To the corporate means a company, whether it is publicly limited company or private limited company, we have to lift the curtain. Veil means the curtain, to see the actual persons, to see the real persons who actually, in real sense, responsible for the whether for the good of the company, for the bad of the company, but they are responsible. The actual controlling power of the company is in their hand. So they actually channelize, regulate the financial matters, regular functionings of the company. Whatever name by name you call directors of the company, or the promoters of the company, or the founder members of the, whatever name you define, but they are the persons, they are the individuals, real persons, who are the real persons who actually runs the company. And why do they need to find out? If their intention is to fraud someone, intention is to engage in forgery element, fake elements, objective is to cheat others. The objective is, if you are not loyal to your organization, if you are not trustful for your organization, because company is an artificial person. Company represented by its members in the form of directors of the company, executive members of the company. If they are engaged in some wrongful activities, ill practices, malfunctioning, manipulation of accounts, that is not acceptable. It is not acceptable. They cannot destroy the name of the company by using their names. So the objective should be legal, should be lawful, should not be illegal, should not be unlawful. So if some persons in that particular board, if their objective, their intention is to dissolve the company, is to downfall the company, is to degrade the company, defame the company in the front of others in the market, and to destroy the goodwill of the company, damage the image of the company, brand image of the company in the market. In that case, there is a need to find out who are these persons who actually tries to defame the company, because company cannot speak. Company cannot speak like a natural person. We can speak our emotions, our feelings like a natural person, like a physical person, but companies cannot express its emotions or feelings. The company can express only by its directors of the company, representative members of the company. If they are involved in some wrongful activities and they are trying to harm the companies, their personal image of the company, the brand image of the company market, then there is a need to find out the persons who are actually runs the affairs of the company and who are actually responsible for defaming the image of the company in the market. So the objective is a fraudulent and dishonest to make the entity, legal entity, illegal entity. The objective is to binding of the firm, dissolve the firm by only for your personal motive, for your personal interest, and for your personal stake. Then this is not acceptable. This is not acceptable, and the individual concerns will not be allowed to take shelter behind the corporate personality, because they have no right to spoil the image of the firm by engage in wrongful activities, and by their ill practices they are not allowed to damage the firm's image, the corporate image. If company cannot speak, company cannot speak like physical person. But company, we can see the downfall. We can see the persons who run the company, the directors of the company, they can feel the emotions. We can feel the emotions because company cannot speak, but we can feel the emotions which company feel. If someone, as a person, we are a natural person, if someone try to destroy our image, what we feel, we can understand. So we should understand about the company, because company is also a separate person, not like a natural person, but company existence or in the eyes of law, like an artificial legal person. So no one has a right, no one has an official right, no one has a right to spoil the name of the company, using the name of the company for their personal purposes, to fulfill their personal motives and desires. That is not allowed, that is not acceptable, and there's a need to lift the curtain, to see the real persons, who are actually responsible for the downfall of the company. So in this regard, the court will break through the corporate shell and apply the principle of what is known as lifting or piercing the corporate veil. So we have to break the curtain. We have to lift the curtain. Otherwise, we see the company is different and its members are different. So there is a veil, curtain that makes it different from its member. Company is different and its members are different. So veil is here, curtain is here. So that makes company different from its member, distinct from its members. But sometimes when there is a need, sometimes there is a requirement to lift or pierce the curtain to see the persons. Then come to the concept of lifting of corporate veil. The corporate veil protects the shareholders and officers of the company. Shareholders and officers of the company. But when the concept of a separate legal entity is misused and any fraudulent illegal activity takes place inside the company, these directors of the company, their family members, their wives, their daughters, their son engage in insider trading, malpractices, ill practices, gambling, money laundering, and if their objective is to they are trying to play any wrong game, there is a need to give them that right direction, that they are going in the wrong direction, and there is a need to watch these persons who are actually engaged in wrongful activities, because no one can use the name of the company which is formed by legal formalities and by legal formalities for their illegal purpose. If your purpose is illegal, if your purpose is unlawful, if your purpose is fraudulent, then in that case it is penalty is there. Penalty provisions are there in the Companies Act to punish the persons, the officers of the company who are responsible for this manipulation in the books of accounts, fudging in the books of accounts, and they are purchasing, using the money, the withdrawals of the company, drawings of the company are using the money, company funds for the personal purposes, for the purchase of the personal cars, personal smart laptops, purchase of land on by using the company funds, purchase of the personal land. So that is not acceptable. The company funds cannot be misused by the members of the company. If it is misused, it should be informed, and it should be some legal action should be taken against the persons who are responsible for this wrongful activity. Then come to the concept of, again this is a continuation of this topic, concept of lifting of corporate veil. Under such circumstances, the court orders the corporate veil has to be lifted, the curtain has to be lifted to determine the following things that happens inside the company. Number one is to determine the true character of the company, for what purpose is company is formed, for which objective company is formed. If the very objective of the company is to fraud with the investors, to fraud the shareholders, or to fraud with the general public, then it should be informed. It should be informed to the ROC. It should be informed to the Company Law Tribunal, and it should be informed to the concerned authorities that company is formed for the illegal purposes, to engage in insider trading, for gambling and all, and for money laundering and all. The purpose should be legal, should not be illegal. Second point is to protect revenue or tax. So for the protection of revenue or tax, if someone tries to avoid tax liabilities and try to avoid payment of their taxes, then in that case those officers who are involved, engaged in the payment of tax liabilities, if they are not paying their dues on time, then there is a need to find out the persons who are responsible for non-payment of the income tax due to the income tax authority, on time. So otherwise, if they are trying to avoid tax liability, if they are trying to make a manipulation in accounts to protect from yourself from taxation liabilities and all, in that case the persons behind this uh, who are involved in avoidance of tax liabilities obligations, there's a need to find out the persons, and there's a need to lift the veil, corporate veil, to find out the real persons who objective is to avoid tax obligations. If we are trying to avoid legal obligations, whatever legal obligations on you, you should bind by the court of law, you should bind by as per the Companies Act, and you are bound to tribunal also uh, for legal obligations. In that case, the persons who are responsible for binding of all the legal provisions, you have to submit all your reports. And if you are trying to avoid illegal obligations, then there is a need to find out the persons who are trying to avoid their legal obligations. So this should be informed, and for this we need to lift the curtain to see who are responsible for avoidance of the legal compliances, because legal compliances are there as per the Companies Act. You have to file your all your documents with the ROC, the MOA of the company, the A of the company, the annual returns of the company, the income tax returns of the company, ITR is there, some certain certain mixtures are there that is attached, certain bills and copies of bills are there, the memo is there. So you have to submit all these records as per the provisions of the Companies Act. And if you are trying to avoid, you are not preparing your annual account as per the accounting standards as issued by ICAI, or as per the generally separate accounting principles, you are not preparing your accounts as per the accounting standards. In that case, you have to answer, you have to reportable to your ultimate authority that for which reasons you are avoiding these obligations and liabilities towards the company, because company is artificial person, company run by its members, and when members engage in trying to harm the company, the personal image, the brand image of the company, then in that case there is a need to find out the persons who actually tries to harm the image of the company in front of general public, towards third party, towards vendors, suppliers, income tax authority, and government and banks. So if you are a company, like a natural person cannot speak, but company believes that their representative represent the company in a better way in front of third party, in front of general public. So trust element is there between the company and its company believes that, not like a natural person, but company believes that the representative members of the company, they comply all the legal provisions in respect of the as per the Companies Act 2013 respect, and complying of all the important documents with the ROC of the company. So anyone who engages in trying to avoid the legal obligations has to be answerable or reportable to the ultimate authority. So why you are, which reasons you are trying to avoid your legal liabilities. Then forming of subsidiaries to act as an agent. For this reason, if you are forming subsidiaries and without informing that to the company that you are forming subsidiaries, and you are acting as an agent of the subsidiaries, in that case you have to inform to the company that you are forming subsidiary of this company and how many subsidiaries of a parent company, holding company, that should be informed. If it is not informed and you are running your subsidiary in secretive manner by using the funds of the company, that is not acceptable, that is not acceptable. And because you are acting as an agent of the company is the principal. If the agents they are engaged in trying to fulfill their personal interest and at the stake of the common interest of the company, and without and disregard to the common interest of the company, in that case there is a need to find out the persons who are behind the formation of the subsidiaries, secretive subsidiaries. We have no information that company have these 10 subsidiaries. We have no information, and the persons who are responsible for the formation of subsidiaries, they are hiding this fact from their shareholders of the companies. So in that case, you have to you have to lift the veil, and you have to find out the persons who are actually responsible for the formation of subsidiaries. The next is, if company is formed for fraud or improper conduct or to defeat the law, that is objective, that is illegal. Objective is illegal. To the if company formed for fraudulent purposes for and you need know that this is these are the persons who are responsible for this improper functioning, improper conduct, then there is a need to lift the curtain, lift the veil of the corporate enterprise to find out the persons whose objective is to fraud others, to cheat others, and if by doing this, by lifting the veil, we know that these are the persons, and we can punish them. We can punish them, and we can penalize them for their fraudulent activities, for their ill practices, malpractices, for their improper conduct. Again, there is a definition that defines the lifting corporate veil. A corporation will be looked upon as a legal entity as a general rule. It is a rule of general rule that company is separate legal entity concept is there, company is different, members are different. But sometimes the company and its members are same. I mean, there is no lift. The company members who runs the company for the fraudulent objectives to engage 420 transactions, and that is a need to look upon the persons who are responsible for the this irresponsible behavior on the part of their members, on the part of the shareholders of the company or the members of the company who engage in this fraudulent activity. Means company and its members are same, because if we apply the rule of companies different, members are different. So members they run away from their liabilities by saying that their liability is limited. But if the member is engaged in fraudulent activities, company is not responsible for their ill practices. Member has to pay. Liability is unlimited because member has to pay. Liability is only limited if you follow the rules regulations as per the Companies Act. But if your objective is to defraud others, if your objective is to cheat others, then this liability, this clause is not applicable to you. You are personally liable because you defame the company and you use the name of the company for your personal purposes. That is not acceptable. Okay, so in that case, company and its members are same, because these are the persons who actually form the company for their personal stake, not for the common goal of the company, but for their personal desires, for their personal goals. They form into a company and to engage in fraudulent transactions. They are engaged in fraudulent transactions, fake transactions. So that is not acceptable. So, but when a notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons. Okay, meaning is that you have to, if you use the law for your personal conveniences, and if you are trying to justify your wrong, that if you are doing wrong but you are justifying that I am doing right, that is not acceptable. Wrong means wrong. If you are doing wrong, it means wrong. Wrong, that is not acceptable. How can you say that this is correct? Wrong means if you are doing not following the provisions of the Companies Act, that is wrong. If you are not compliant as per the Companies Act, not submitting your documents on time, that is wrong. If you are justifying that your wrong is good, that is not acceptable. You are protecting yourself, you are protecting fraudsters, you are protecting your gang of fraudsters, and you are protecting criminals and because they are criminals, because they are involved in 420 transactions, fake transactions, so that is not acceptable. So in that case, companies artificial person, companies not speak like a natural persons, uh, and to give justice to the company, there is a need to lift the veil. That's why justice to the company. So the company, as a separate legal entity concept, has to be lifted to find out the real persons. Then come to the comparison between private and public company. There's certain distinction, you can say, difference between private limited company and public limited company. So on the basis of comparison, on the basis of minimum number of members that is required for the formation into a public company or into a private company. So minimum 2 is required. 2 is required in the case of private company, and 7 is required in the case of public company. That is a minimum limit for the number of members in the case of private limited company. That only 2 does not mean that it is partnership, it is a company. In case of partnership, 2 person can start into a partnership, but that is not in the case of private company. In the case of private company, minimum 2 is there, but that is a company, that is not partnership. But in the case of public company, at least 7 members is required to form into a company. Then maximum number of members in the case of public limited company and private limited company. In the case of private company, maximum number does not exceed 50. Maximum numbers does not exceed 50. Now it is 200. But in the case of public company, there is no restriction on the maximum number of members. Then come to the name. The name of a public company limited by shares or by guarantee must end with the word limited after the name of the company, and private company limited by shares or by guarantee must end with the word private limited. This is a name. How can you call a company, that is, how can you say this is a private limited company, this is a public limited company? By having this name, you have to use the word limited after your name, after the name of the company. Limited in the case of public limited company and private limited in the case of private limited company. The name gives you identity, that gives you recognition that this is a public limited company, this is a private limited company. Then come to the transferability of shares. The shares of public limited company are freely transferable, but that is not the case of private company. There are certain restrictions on the transferability of shares in the case of private company, because membership is restricted to family members, friends and relatives. So there are certain restrictions on the transfer of shares.